FIL, China's Foreign Investment Law, which had its first draft circulated in 2015 and finally became law in 2019, has been in effect since the 1st of January 2020. At the same time, the original three laws on foreign investment for equity joint venture, cooperative joint venture, and wholly foreign-owned enterprises were repealed. This is a significant change for the existing foreign invested companies in China and also for the new greenfield foreign investment. So, why this is a big change and how will it impact on your business? Let's take a look. The original three foreign investment laws, they were firstly issued between the end of 1970s and the end of 1980s, are actually much earlier than the Chinese company law. The three laws introduced the legal forms and concepts of modern corporate entity into China and played an important role in China's rapid economic growth. All the foreign invested companies in China were subject to the three laws, while the domestic companies were subject to the company law. But as China is opening up its economy in the recent decades, especially after China's accession to WTO, the two separate regulatory regimes, one for domestic companies, another one for foreign invested companies, began to converge under the WTO's principle of national treatment. FIL signifies the completion of this converge because after the FIL takes effect, all the foreign invested enterprises will be subject to the company law. They will be under equal standing with domestic companies. This change does not only apply to the newly established companies, but also applies to the existing ones. So, how will this impact on your business? We could summarize into 3 points. 1. From the New Year's Day of 2020, you could throw these three laws into the rubbish bin and start to read the Chinese company law. Consider how you want to build your company's governance structure under the company law. 2. In the older three laws, there are a lot of administration and limitation provisions. But with the foreign investment law, the only main limitation is a negative list. It means, as long as the business does not fall into the prohibited or restricted category of the negative list, you could be able to register easily and have the equal national treatment as domestic companies. Meanwhile, the negative list will be updated from time to time and there will be more sectors to be opened up by the Chinese government. 3. If you are owning an existing foreign invested company, you will have a 5-year transition period to complete the conversion process. So, the New Year's Day of 2025 will be the deadline. Don't take a risk to wait until the last minute. Also, if your existing company is joint venture, it's time for you to prepare for the renegotiation work with your business partners. As the company law gives more freedom and flexibility to the shareholders, it means the conversion process will not only be limited to the administrative conversion. In many cases, there will be full renegotiation on joint venture agreements and articles of association between shareholders. Okay, this is a general introduction of FIL. Hopefully it helps you have some general understanding of this change and enjoy the dividends of this reform. Thank you for watching. See you next time.